Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we have already discussed about more than 65 videos, and in most of those videos when we were discussing chapter 1 and 2, the repeated terms that I have discussed was the relevant facts and facts in issue. Now, this is what Evidence Act all about. We have to give evidence for the relevant facts and facts in issue. But there is one brief chapter, that is chapter 3, which is covered between section 56 to 58, just 3 sections, which says facts which need not to be proved. Here we need to understand one of the important legal terminology, that is judicial notice. So what I am doing here is I will cover all the 3 sections in this one video. That means we are going to cover chapter 3 in just one video, where I will help you guys to understand all the 3 sections along with the term judicial notice. Not taking much of your time, let's get into the first slide. As I have already told, Evidence Act is all about giving evidence and proving the relevant facts or facts in issue. But as I said, chapter 3 is a kind of exception where there need not to be proof few of the facts based on these 3 sections. First section, that is section 56, discusses about fact judicially noticeable need not to be proved. Now the section says no fact of which the court will take judicial notice need not to be proved. Now if the court can take judicial notice of a particular fact, that need not to be proved as under section 56. Now what is judicial notice? I have given 2 definitions here. The first one says judicial notice signifies notice on recognition of the truth of the facts taken by a judge without requiring proof by any evidence. That means there is a discussion of a truth and there is a particular aspect to be recognized by the court, and the judge sitting in the court will not ask anything to believe such fact, or he is not asking the advocate to give any kind of proof. That is called judicial notice. On the other hand, judicial notice is a rule in the law of evidence that allows a fact to be introduced into evidence. That means here a fact comes into evidence if the truth of that fact is so notorious or well known. Now everybody knows that this is a truth or this is a fact. So when that happens, or so authoritatively attested, now there are no doubt, it is beyond any reasonable doubt. In that case, what happens? That it cannot reasonably be doubted. This is done upon the request of the party seeking to rely on the fact at issue. Now when that happens, when there is a truth in front of the court, when there is a fact in front of the court which is notoriously known or well known or authoritatively attested, and there is no doubt on such fact or truth, in that case the court will also agree that yes, such fact is there or such truth is there, and the same need not to be proved again. That is all about judicial notice. I have 3 case laws here and 3 important statements, and these statements are quite easy. I am not going to explain them. For the benefit of those who are listening, I will just read out those important statements. The first one, that is in the case law of Jaishankar Prasad versus the state of Bihar, it was held that blindness by itself is not a physical infirmity. We take judicial notice of the fact that many blind persons have made a name for themselves. Many blind persons have acquired great academic distinctions. As general public, we also have observed that lot of blind people have proved themselves. So that is what held here, that not every blind person cannot prove anything. That is not an assumption. The court should take a notice that there are many blind people who have proved themselves, and that is considered as judicially noticeable aspect. That is in the case law of Jaishankar Prasad versus the state of Bihar. Then I will take you through the observations made by Lord Stephen, who says that certain facts are so notorious in themselves or are stated in so authentic manner is well known and accessible publications that they require no proof. The court, if it does not know them, can inform itself upon them without formally taking evidence. These facts are said to be judicially noticed. There are many facts which are known to everyone. Everyone know that they are authentic. They are accessible via publications, etc. In that case, if the court is not aware, it can formally take evidence by itself, and these are called as judicially noticed. Finally, to make it very easy, I will bring the statement made by Justice Isaac in the case law of Holland versus Jones. He says, when a fact is so generally known that every ordinary person can presume to know it, then the court will notice that fact either simply or after such investigation as would be necessary to eliminate any reasonable doubts on that matter. So, if a fact is known to everyone, in that case, it is assumed that the court should also know that. If in case there are few doubts, in that case court can have brief investigation and remove those doubts, but it is simply assumed that the court is also aware of all these things and the court has to accept that which is known as judicially noticed. I hope that is very clear. With that, let's move on to section 57. While section 56 focuses on what is judicial notice, section 57 brings a list of those facts of which court must take judicial notice. There are as many as 13 such facts which are listed under the Act, but all I want to say is this is not an exhaustive list. There can be many other facts also which will be used as and when relevant, but for now there are 13 facts which are available in the Act, and I am not going to read out all the provisions, but the notes is available. Let us quickly go through few of the important aspects covered here. Court has to take judicial notice of all laws which are in force in India. It has to take judicial notice of all the acts passed by the Parliament of India. It has to judicially notice the articles of war by the Indian Army, Navy or Air Force. It also need to give judicial notice of the proceedings of Parliament. It also should respect all the signed manual by the sovereign. It also need to judicially notice all those court seals which are formed by the central government of India. The accession to office, names, titles, functions and signatures of the persons filing for the time being any public office in any state if the fact of their appointment to such office is noticed in any official gazette is also judicially noticeable. The eighth aspect judicially noticeable by the court is the existence, title and national flag of every state or sovereign recognized by the government of India. Here every state means every country, that is the legal language we need to understand. Then the ninth one, it should take judicial notice of division of time, the geographical division of the world, public festivals, holidays which are in the official gazette, all of that to be judicially noticeable. The territories under the government of India to be recognized, the commencement, continuance and termination of hostilities between the government of India and any other state or body persons, then the name of the members and officers of the court and their subordinates, finally the rule of the land, road or sea. All of these need to be judicially noticeable by the courts. Now, these are the 13 provisions which are mentioned, but this is not an exhaustive list. In all the above cases, as well as if the matter is related to public history, literature, science or art, and if court has certain amount of doubts, it can ask for the reference book or documents. In such case, the parties need to produce such books or documents, whatever need to be referred. Only after referring, the court can come to a conclusion. But if such person is not providing such books or reference, then the court can deny the same. Coming to the case laws for section 57, there are a lot of case laws available. You need to go through the case laws as per the books referred by your university. But I am bringing in two important case laws here. The first one, which is related to question on existence of custom. Now here in the case law, that is Atluri Brahmanandam versus Anne Sai Bapuji, where the reference was taken by another case law, that is Ujagar Singh versus Geo. Here it was held that if everybody accepts that a particular custom is available, or if a general custom is known to everyone, in that case the court should take judicial notice of the same. There need not to prove the same again. That is what held in these two particular case laws. The second case law that I am discussing here is United India Insurance Company Limited versus Virambhai Ranchod Bhai. Here what happened, a housewife died in a road accident. Now there was a discussion on the insurance amount. The court here held that the housewife is giving lot of service in her home, and her salary, if there was to be any, will also increase over a period of time. Here the case law referred another case law of Lata Wadhwa versus State of Bihar, and it was held that the payment of insurance should consider increment of the value of service of a housewife. This is a beautiful judgment which recognized that housewife is also kind of a job which is done by most of the Indian women, and it need to respect that there is increment for the value of such services. That is what held in this particular case law. The last section, section 58, discusses about facts admitted need not to be proved. The section is very clear. If the facts are already admitted, they need not to be proved again. What does the section says? It says no fact need to be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force at the time they are deemed to have admitted by their pleadings. There is one exception here, provided that the court may, in its discretion, require the facts admitted to be proved otherwise than by such admissions. To make this section easy, I have my chart below, where the chart is all about those facts which are need not to be proved. What are those facts? Under three circumstances. The first one, the green box, parties or agent of those parties already agreed that they are going to admit such fact in the hearing. In that case, such fact need not to be proved. In the second instance, that is blue box, before hearing, before even the proceeding started, the parties have agreed in writing that they will admit such fact. Such fact are also need not to be proved. And finally, as rule of law in force deems that party has admitted. Now, if the rule of law considers that the party has already admitted, such facts again need not to be proved. That is all about section 58. And what is the exception? Court in its discretion may ask to prove the fact which is admitted. Court has the right to ask the parties to again prove on such admitted facts. That is the discretion of the court.
Do you know what is the difference between squirrel and Nishan? Think, 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 think. It's very easy. Squirrel has sharp teeth in front of its mouth, and I don't have any.
Nishan, what's happening there?
Nothing, Papa. With that, I'm concluding this session. Please subscribe our channel. Please like, share, and comment our videos. Thank you. Bye-bye.